But this is,
Hello, Wayne. I don't think the state's coming over.
unmute. No?
Wayne, do you hear us?
I hear you. I hear you.
Okay. Hey, listen to it. Do you hear us better?
I hear you really well. I have a little feedback though. Talk to me.
How you doing?
How you doing? How you doing? No, you sound okay. Maybe it was because you were so close a second ago.
Okay.
Good
Okay.
look.
Yeah, Fabio.
I didn't touch it. See, it goes away on its own.
Hey,
Yes,
y'all,
ma'am.
your vibe, not Memorex, okay?
Yeah, I know.
Okay.
State Ram, how can you hear me? Everything clear?
Yes, sir. How's your end?
Works good.
On the first one, Johnny Hamilton, he does not have a court-appointed attorney. We're told that he's on suicide watch. They received him from a mental hospital, so I'm gonna go ahead and appoint Richard Smith on him,
Okay,
but we're not gonna arraign him today, if that's okay.
that is fine. I'll let Richard meet with him and he can file a waiver or something, but we do need to set it though.
Okay,
We'll just set it for that, November 28th date that Mr. Schmidt will be back.
11/28.
11/28 is.
Hamilton. We're not bringing him up. He's on suicide watch. Okay, and then on the next one, Audie Yarborough, he also has requested a court-appointed attorney, and has, he needs a court-appointed attorney. Mr. Manning is present this afternoon. And he is going to arraign him if you will, put the indictment up for us.
Okay, you ready for me to do that now?
Yes, sir.
Yeah, reset. Hold on.
All right, for the record, this is cause number CR 23-195, State versus Audie Bailey Yarborough. Court has appointed the Honorable Jonathan Manning as court appointed counsel upon Mr. Yarborough's request and finding of indigency. Go ahead, Mr. Manning.
Yes, Judge. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. At this time, he enters a plea of not guilty and requests to be set on the pretrial docket.
All right, court finds the defendant has waived the formal requirements of arraignment. Court will find his name is spelled correctly. He does understand what he's charged with, and the court enters his plea of not guilty into the record. Court sets this matter for pretrial hearing. You want this set on December 14th, Mr. Moon?
Judge, just give me a moment, please. Judge, that will work.
All right, court sets Mr. Yarborough for a pretrial hearing on December 14th at 1:30, unless he makes bail. If he makes bail, the hearing will be at 9 a.m. on that same day.
Sorry.
Are you in there? Are you working outside? Okay.
Where else are you ready on, Mr. Manning?
Judge be set out to the next contested evidentiary docket.
All right, court sets Mr. Penny. I'll vote for the contested docket on November 30th at 1:30.
Sir, I'll see you, buddy. Judge, I believe that concludes on business. May I be excused.
Yes, thank you, Mr. Manning, appreciate you. State
Okay,
Ram,
Oh, yes, sir.
who's next?
Oh, Mr. Adams with Chastity Smith.
All right, Chastity Renee Smith, CR 22-49, docket call. Good afternoon, Mr. Adams.
Good afternoon, Your Honor. Mitch Adams on behalf of Ms. Smith. Your Honor, I'm pleased to announce that we have a signed plea agreement in front of us, and if the court would like, I can read the details to you.
Yes, sir, if you would be so helpful.
Okay. In cause number CR 22-00049, Ms. Smith is charged with the state jail felony offense of unauthorized use of a motor vehicle. She is going to plead guilty to that in exchange for PDC state jail division and be fined. State would also has also offered to under section 23-0479. In addition to the state jail time and the fine amount, there are court costs of $290 and a reimbursement fee of $155. According to the judgment, Ms. Smith is to be given total jail time credit of 180 days toward her sentence.
Great, thank you, Mr. Adams, I do appreciate that.
Yes, sir.
Ms. Smith, if you'll raise your right hand, ma'am, I'm gonna place you under oath.
Sir.
Ms. Smith, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do. Yes, sir.
Thank you, you can lower your hand. All right, your name is Chastity Renee Smith, is that correct?
Yes, sir.
And Ms. Smith, are you a United States citizen who does read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams and the work he's done for you as your attorney?
Yes, sir.
Do you feel like you've had enough time to discuss with him your case to the point that you've had all of your legal questions answered and that you understand everything that you've read and signed today as part of your plea agreement?
Yes, sir.
And Mr. Adams, do you believe your client to be competent? And if so, do you believe that she, after being advised by you, is entering into this plea intentionally, knowingly, and voluntarily?
Yes, Your Honor, Ms. Smith is mentally competent. She knows what she's doing here today.
All right, and Ms. Smith, you heard Mr. Adams read to the court the plea agreement in your case. Is that your understanding of the plea agreement and what you're asking for to approve?
Yes, sir.
All right, Ms. Smith, I must admonish you that on the charge of unauthorized use of a vehicle, that is a state jail felony and does carry a range of punishment. Not less than 6 months or more than 2 years confinement in a state jail division of the Texas Department of Criminal Justice, and a fine, if imposed, of not more than $10,000. I see that the recommended sentence and plea agreement does fit lawfully within the range of punishment. So at this time, Ms. Smith, I would ask you, how do you plead to unauthorized use of a vehicle, a state jail felony?
Guilty, Your Honor.
Are you pleading guilty, Ms. Smith, because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty here today?
No, sir.
The court does accept the defendant's plea of guilt. Mr. Adams, is there any objection to the stipulation of evidence being admitted?
No objection, Your Honor.
All right, the stipulation of evidence is admitted and the court does take judicial notice of Ms. Smith's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, Your Honor, we rest.
Okay, just to clarify, so there is no restitution being ordered in this case with regards to the unauthorized use of a motor vehicle, the burglary, or the theft. Is that correct?
That's correct, Your Honor.
Okay. All right, and Mr. Adams or Mr. Hartwell, whoever has the stipulation in front of them, can you recite that to the court on the record, please?
Yes, Your Honor. Bear with me 1 second.
Yes, sir.
Okay, I'm getting there.
I have confidence
Mr. Hartwell, help me out. We're every county's
Yeah,
different.
I just emailed it over, so it may not be in that packet. I can go ahead and read it off though.
Okay, thank you.
On or about September 16th, 2021, in Van Zant County, I, Chastity Smith, took the keys to my mother's car and took the car without her permission to my boyfriend's house.
All right, thank you, Mr. Harwell. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Smith of this offense. The court will follow the plea agreement today. The court hereby convicts Chastity Renee Smith of unauthorized use of a vehicle. Court assesses her sentence pursuant to the plea agreement at 6 months confinement. The Texas Department of Criminal Justice State Jail Division assesses a $1,500 fine. The court orders court costs of $290, reimbursement fees of $155. The court dismisses under section 1245 and takes into consideration unfiled DA case numbers DA 2023-479, DA 2023-89. In addition, the court awards Ms. Smith 180 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Smith, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Once you are released from the jail, then I want you to report over to the courthouse, to the district clerk's office, and speak with them about making arrangements to pay your fines, court costs, and reimbursements. Okay.
Yes, sir.
Failure to satisfy the terms of that order will result in the court issuing a warrant for your arrest. Okay, so I want to make sure that we tend to your business.
Yes, sir.
All right, please step over with the deputy so they can take your fingerprint.
Thank you.
Are you looking for them?
Mr. Adams, you ready on Mr. Copeland?
Yes, Your Honor.
Rusty Wayne Copeland, CR 23-93 for pretrial. Go ahead, Mr. Adams.
Good afternoon, Your Honor. Mitch Adams on behalf of Mr. Copeland. I don't have any pretrial issues to bring to the court's attention this afternoon. However, I recently received a plea offer from the DA's office regarding Mr. Copeland's case. He and I have not had an extensive amount of time to review the pros and cons of that offer and decide what we want to do. We're set for pretrial today. What I'd ask the court to do is set us for a docket call and give me some time to visit with Mr. Copeland and give him my advice, and then he can give me my marching orders.
Yes, sir. I can set you in December on December 12th or 14th to the one you prefer.
I think I can be, the 12th will be fine. I think I can make it back from Lufkin in time.
Okay. All right, court sets Mr. Copeland for docket call on December, you said 12th, correct?
Yes, sir.
December 12th at 1:30. And if you're just gonna be late that day, just let Ms. Tabor know. We'll make sure we wait.
Yes, sir. Will do. You see me? Yeah, you're gonna see me Friday.
Whatever you want to do. Just
Yeah, I've got nothing to do Friday morning. Oh, I got nothing else to do Friday morning. I'll come over and sing. All right, go credit. Appreciate it. I'll take a picture of this. Judge, that's all. Formally, that's all I have on the docket this afternoon. May I be excused?
Yes, sir. You're excused. Good to see you. Thank you for being here.
I see, Judge.
All right, Ms. Tabor.
We do not have Mr. Hawkins or Mr. Lowe present at the jail.
Okay.
We do have the extradition, Mr. Klitsch here. If we can go ahead, if you want to go ahead and do it while we're waiting.
Sure.
For Klitsch.
All right, sir. Is your last name pronounced like it's spelled cliche?
Yes, sir.
Okay. So your name's Remy Cliche?
Yes, sir. Yes, Your Honor.
All right. All right, Mr. Cliche, it looks like in looking over your paperwork. looks like you are wanted in, Volusia County, Florida. Out of the circuit court there in the 7th Judicial Circuit. It appears that you're wanted for a criminal offense of DUI crash with serious injury. Leaving the scene involving serious bodily injury. And also additional charge of leaving the scene with injury, maybe multiple people on the vehicle. Anyway, so you're being held here in Van Zandt County on those warrants out of Florida. The fact that you are wanted by a law enforcement agency in another state means that they can't just show up and ask us to turn you over to them. You have to acknowledge your rights of extradition, and then you have to determine whether or not you want to be formally extradited back to the state of Florida, or once I explain to you what extradition is, then you'll have a decision on whether you want to invoke that right or you want to waive your right to extradition. And so, Mr. Cliche, you do have the right, because you are wanted in another state, you do have the right to require that state to formally request your being returned to their state through what is known as a governor's warrant. And that is really the formal process of extradition. And how that works is, now that you've been arrested on the Florida charge and you're being held in Texas, the only way that you can return to Florida is two ways. You are extradited by Florida, and that means that Florida sends their paperwork over to their governor's office, and their governor's office will certify that information. If it's all in accord with their law, they will then forward it over to the state of Texas, to its governor's office. That governor's office will then retrieve the information from our county, and then if it's deemed that you are in fact the person who is wanted in Florida, then once your identity is affixed and the criminal procedure regarding extradition is satisfied, then you can be formally extradited back to the state of Florida by the order of the governor of both the state of Texas and the state of Florida. Throughout that extradition process, you are entitled to the appointment of an attorney. During the extradition process, if you cannot afford one, that attorney does not defend your criminal cases or the criminal accusations against you. However, they would advise you and give you legal representation whether or not the extradition process has been lawfully followed. Okay, and so that process could take up to, greater than 30 days, 60 days, 90 days. It depends on how long it takes the state of Florida to send their information over to Texas and for it to be certified through the respective governor's offices. Okay. And so that's really in a nutshell. I know I got to explain all this to you before you tell me what you want to do. Okay. And so that's the formal process of extradition, so that you do have the right to an attorney during that process if you want one appointed to you. If you understand your rights, you're telling me, Judge, I understand what my rights are of extradition. I understand that I have the right to an attorney during that process, but I intentionally, knowingly, voluntarily waive that, then you can waive your rights and tell the state of Florida that you will voluntarily go back into their custody. And if you waive your right, or approves your waiver, then we'll notify the state of Florida and they can come and pick you up. Usually within 7 to 14 days. It may take a little longer than that because they're a little further away. In any event, if you're still here within 30 days, then I would have another hearing with you, and we would determine whether or not you could be released on bail. If they don't pick you up within 30 days, and I don't know that there isn't a date certain that they're coming to pick you up. Does all of that make sense?
Does that include on the past 3 days?
I'm sorry, say that again.
Does that include the last 3 days also?
No.
Or is it start now?
It's going to start today with the extradition, because they're not going to know. The only way that they're going to know to make arrangements to come pick you up is for us to tell them that you're either waiving extradition or you're requesting to be extradited.
10-4. Yes, Your Honor.
So do you have you had an opportunity, and I believe that we had some paperwork provided to you regarding your right of extradition.
Yeah, I'd just like to be extradited.
Have you read over that?
Or you want to waive?
Yeah, I want to waive it.
Okay,
In
so,
other words, I want to be sent back.
okay, so you're telling me that you voluntarily waive your right to extradition. You
Yeah.
consent to picking you up so that you can return to Florida fast.
Yes, yes, Your Honor.
Okay,
Yeah.
all right, then, Mr. Cliche, if you will sign that waiver of formal extradition where it says defendant, then it'll be sent to me. I will sign it as well. And then the jail staff there will communicate with Volusia County in Florida and let them know that you have waived extradition and that you are ready for pickup. And they will let me know if you're not picked up within a reasonable amount of time, up to 30 days.
So then after 30 days, I'm gonna come and see you. You're gonna set me a bail.
Potentially so, potentially so. If they're not here on day 30, but they tell me they're gonna be here on day 32, then I probably would not set you a bail. But if day 30 comes around and we've not heard anything from them, and you're still here, then yes, I probably would set you a bail. And that way you can post it and move on.
All right, thank you, Your Honor.
Hey, you're welcome. Do you have any other questions, sir?
No, sir.
All right, great. You have a good day.
Me too.
All right. Go ahead.
All right, so do we know where Mr. Lowe and Mr. Hawkins are?
No, Your Honor. I've asked Ms. Barker to contact Mr. Hawkins. I believe Ms. Curry said that Mr. Lowe thought he was set for 3 o'clock.
That's correct, Your Honor. I talked to him earlier about potentially reaching an agreement, and he told me that he thought this was set for 3. I told him I believed it was 1:30.
Well, and if he is set for 3, I mean, I'd have to look on the notice of setting, but there are those times where the attorneys tell me they're bouncing between courts. Sometimes I tell them on the docket, hey, as long as you're here about 3, that'll be fine. So we'll wait and see when he gets here.
Okay, thank you, Judge.
You're welcome. All right, we'll stand in recess until we hear from Mr. Lowe and Mr. Hawkins.
Okay.
He was right. That's okay.
All right, the board called written number WR 23-00084, Jonathan Lee Lyons versus the state of Texas. Mr. Lowe, are you ready to proceed, sir?
I am, Your Honor.
All right, let me see if I have my prosecutors here. Okay.
Yes, sir.
There's Ms. Curry. All right, Mr. Lowe, do you want to call your client to testify at all today?
Well, so, Your Honor, real briefly, he's been incarcerated now for about 60 days. And so we've got this misdemeanor class A. So I think he probably would be entitled to PR bond on that one.
Is the writ? Let's see.
And so, Your Honor, just a second.
I'm sorry, I couldn't hear you. Say that again.
So, I've told the court in the last hearing, and I've told the district attorney, this hearing is about bond reduction. And so I advised the court, I got a copy of the offense report there's 4 offenses. So I'm not arguing about probable cause. I just think the bonds in these cases are absolutely ridiculous, or what the charges and what the offense report says. So I think he's entitled to the PR on the, which we hadn't been here long enough for those others. So I guess we need to dispose of that first, Your Honor. See if he's.
Okay, so I guess I'm a little confused. So you're asking me to grant a PR on a class A misdemeanor. I don't even show a class A misdemeanor before me. What I show is a delivery of controlled substance or marijuana to a child, harboring a runaway child, possession of controlled substance penalty group 2 less than 1 gram, and possession of controlled substance penalty group 1 or 1B less than 1 gram. I don't have any information about a misdemeanor offense in this writ.
Harboring a runaway is harboring one money is a class A, and the bond's $50,000.
Okay, that's the class A.
Yes, sir.
And you said he's been in jail how long?
September the 3rd.
And Your Honor, that is, Mr. Lowe is correct. That is a Class A misdemeanor. However, under 17-151, he's only entitled to a PR bond if that is the only charge holding him. Clearly here, it is not the only charge holding him.
Okay. Want to respond to that, Mr. Lowe?
She's correct, Your Honor. I think that the poor quality of these cases, though, if you have a chance to look at the exhibits that I filed, and I'll offer them at appropriate time, it's absolutely ridiculous about a bond. It's ridiculous.
Your Honor, and we object to the court considering any quote exhibits that were filed that were attached to a motion by Mr. Lowe, as they have not been authenticated as true and correct copies.
That respond, Your Honor?
And Mr. Lowe, why don't you go ahead and offer whatever it is that you want to offer so I can consider it, rather than just referring to them. Tell me what it is you're offering and on what grounds Ms. Curry can object, so I can. Yes,
Your Honor. So I have filed, and I gave copies to Patty, not Patty, the other lady, copies of the documents that are attached as Exhibit A and B, and I'll call myself to authenticate those, Your Honor.
Unless he's a records custodian of whatever police agency he's going to assert they are from, I don't believe that authenticates them, Your Honor.
Go ahead and lay some foundation for exhibits A and B so that we can refer to them on the record as to what they are and to whom they're from, so that we can move along in this here.
Okay, so there are 2 exhibits, and let me get my glasses, Your Honor. Exhibit A is called it has title overdose.
Okay.
Exhibit B is called Runaway.
Okay,
All right, and Your Honor, I didn't take the oath.
well, I'm not sure I'm comfortable with you authenticating these. I'm not sure that you have personal knowledge regarding whether what's contained in these records are just contemporaneously kept, if it's kept in the normal course of business. If I allow an attorney to authenticate what they're giving the court, then I'm not sure that we would need the rules of evidence anymore. So just go ahead and tell me what is Exhibit A and tell me what is Exhibit B and offer them so that Ms. Curry can object so that I can tell me what they are, where you got them, what they purport to be, the relevance, so that she can make her objections. If
I'll make a proffer of proof then, Your Honor. My name is Doug Lowe. I'm an attorney licensed to practice law in the state of Texas. I've been licensed since 1979. Prior to, I'm sorry.
I didn't say.
Okay. I was elected district attorney for Anderson County for 16 years. Before that, I was a board certified personal lawyer. I'm licensed by the United States Supreme Court, the Fifth Circuit, the Eastern District of Texas, and also licensed by the Territory of Americans. And with respect to exhibits A and B, Your Honor, I made an open record to the city of Wills Point. Paid my $6 to the city of Wills Point, went to their office, and their secretary and I, her assistant, not sure what her name is, provided me with copies of the offense reports. These actually, although there are 2 exhibits, there are actually 4 different charges. So, Your Honor, since that time, these are just the narratives. There are other different pages, but these are the narrative portions of those reports. And I'll offer these as an exception to the hearsay rule set out in the rules of evidence 1013, in that for bond hearings, the rules of evidence hearsay rule don't apply. So that's my testimony as far as authenticating or in offering these exhibits. That's our proffer of proof.
Thank you, Mr. Love. Ms. Curry, any objection?
Yes, Your Honor, state objects. I am not making a hearsay objection. I understand hearsay, but hearsay is different from authentication. And we object in that they have not been authenticated in any manner. There is nothing that indicates that they apply to the offense for which this man is charged today, the offenses for which he is charged today. There is nothing that indicates that they are final reports. There's nothing that indicates they are, in fact, legitimate reports made at or near the time by someone with knowledge in the Wills Point Police Department.
Thank you, Ms. Curry. Any response, Mr. Love?
So, Your Honor, the reason that we reset this today, if the court will call, is I offered the state to have time to review these documents and get whatever they needed to be able to see if they were what they were, to evaluate the case and to look at these documents. And apparently today is the first day they actually looked at what I had. So I think the state's being disingenuous in their objection. Also, the rule, as I recall, says that the rules don't apply in a bond hearing.
And Judge, I'm sorry, I thought he was finished.
Not just the hearsay rules, but the of the rules. So we're offering these under a proffer of proof as evidence that authenticated by virtue of I was the one that went and got the documents. The city Wills Point gave them to me under a lawful open records request.
Thank you, Mr. Love. Ms. Curry.
Today is absolutely not the first day that we have seen these documents. I personally saw them last week, the day he filed this. The reason this hearing, my recollection is the reason this hearing was put off was because he had just filed them that morning last week, and Mr. Hartwell, who was physically in court that day, although I was on Zoom, Mr. Hartwell, who was physically in court, had not had a chance to see them because he had gone straight to the courthouse and had not, in fact, seen the email from the e-file system that contained these documents attached. So yes, I did see them myself, whatever the last day was, sometime last week or the week before, the actual day that they were filed. However, this is a bond hearing, not a probable cause hearing. Mr. Lowe has both orally and in writing told us that he is not challenging probable cause. This is a bond hearing. It is his motion and his burden to have a witness here to support the document that he is attempting to offer into evidence, and we continue to object.
Ms. Curry, do you want to respond to Mr. Lowe's assertion that the rules of evidence do not apply to hearings regarding bail reduction, issues of bail?
I think the rules of evidence, I think that's correct, Judge. The rules of evidence themselves do not apply, but there still has to be some authentication, some proof that it is what it purports to be. And we have nothing. This could be a first draft preliminary report that a final is not done yet. There's nothing even on this report to say it purports to the offense. It pertains to the offense for which he is in jail right now, the offense for which Mr. Lowe is seeking a bond reduction.
Mr. Lowe, is there anything in Exhibit A and B that is directly relevant to your client?
Yes, Your Honor, he's mentioned in both reports. And they go to his location at the time the drugs were seized for the state jail cases, and his involvement in the misdemeanor, and also his involvement in the delivering of controlled substance to a minor. So he's in all those reports. He's mentioned his.
All right, the court will overrule the state's objections to the admissibility, the authentication of exhibits A and B. The court will admit exhibits A and B for purposes of this writ and the consideration of bond. Go ahead, Mr. Lowe.
Thank you. So I need to call my client on the issue whether or not what bond he can make.
All right, Mr. Lyons, you'll raise your right hand on the place you under oath. Mr. Lyons, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Go ahead, make sure we speak. You can lower your hand. Go ahead and make sure we speak one at a time. Go ahead, Mr. Lowe.
Yes, Your Honor. State your name, please.
Jonathan Lyons.
And are you presently incarcerated in the Van Zandt County Jail?
Yes, sir.
And you have 4 bonds, is that correct?
Yes, sir.
A bond of $100,000 for delivery of controlled substance or marijuana to a child.
Yes, sir.
A bond of $50,000 for harboring a runaway child, misdemeanor class A. Correct?
Right.
Possession of a controlled substance, penalty group 2, less than 1 gram, state jail felony, bond of $10,000.
Yes,
Correct.
sir.
And then finally, a possession of controlled substance, penalty group 1, less than 1 gram, state jail felony bond, $10,000.
Yes, sir.
All right. Are you able to make those bonds?
No, sir.
All right. Tell me where you were living prior to your arrest.
In the garage of the home that they came to.
All right. And do you pay rent?
Yes, I pay just for the garage part. I don't live in the front area of the house. And where we live at is in the garage.
Let me stop you. Just try to just answer the question. You live in the garage?
Yes, sir.
All right. How much rent do you pay?
Like $2 something just for the garage.
All right. And do you have a regular job?
No, sir.
What do you do for money?
I mow yards.
All right, and who lives there with you?
My wife,
And what's her name?
Devin Dunlaps.
Does she have a job?
No, sir.
All right. Do you own any real estate anywhere?
No, sir.
All right, as far as personal property, do you own a car?
No, sir.
Do you own a truck?
No, sir.
Any vehicles of any kind?
No, sir.
What property do you own?
I don't have any property.
Well, you do you have a lawnmower that you use? For
Yeah,
your-
I have a lawnmower.
Any other tools that you have?
Just stuff to do with lawnmower equipment to do yards. I got a weed eater, a lawnmower, and stuff like that.
Do you have a bank account?
No, sir.
Do you have any stocks or bonds?
No, sir.
Do you how much cash? If I turned you over and shook you out, how much cash would you have in your pockets before you were jailed?
Zero then.
Okay. All right. So are you the bonds now? I think a total of $170,000. You can't make that. We've talked about that there is a bond that you think you could make
10,000.
for all these cases,
Right.
Or however the judge would want to divide that up. You can make a $10,000 bond.
No, sir.
No, I just said you could.
I probably could, but I mean, I have to sell my lawnmower equipment and what I have to work with.
Okay. Well.
I mean, I've just got to be honest.
Okay, well, so are you able to make, if you sold your equipment, are you able to make a $10,000 bond?
Probably so.
All
Yes,
right,
sir.
all right. And after you, if the court set a bond and gave you bond conditions, would you be agreeable to stay in the county? Van Zandt County?
No, sir.
You can't stay in Van Zandt County?
Yeah, I stay in Van Zandt County. Yeah.
You're not gonna leave,
Oh,
right? Are you willing to report to the probation department?
yes, sir.
Mr.
We are
Carl?
going.
Mr. Carl, bond supervision officer, you're willing to report to him?
Yes, sir.
And you're willing to have any conditions of like wearing a monitor or ankle bracelet
Yes,
or
sir.
curfew?
Yes,
Willing
sir.
to have all those bond
Yes, sir.
conditions? And are you willing to provide the court or the probation department your analysis assessment
Yes, sir.
or anything that they want?
Yes, sir. Anything they want.
All right. That was for limited purposes of his financial ability to make a bond, and we'll pass the witness, Your Honor.
Thank you, Mr. Lowe. Ms. Curry, any questions for Mr. Lyons?
Yes, Your Honor. Thank you, Judge. Mr. Lyons, how many bondsmen have you talked to so far?
No, none, ma'am. Cause I knew I couldn't make them.
So you haven't tried to talk to a bondsman at all? You haven't tried to make a bond at all?
No, sir. I couldn't make 170,000. I can't make that.
How much money would that take?
A lot. Well, like what? $15,000? At least that.
And has a bondsperson told you what it would take?
I haven't talked to one, man, because I knew I couldn't make it. So I'd be like,
Has anyone in your family talked to a bondsman?
I don't know that because I only talked to my wife one time, and she was telling me about the medications they found in a pill bottle that was already in the garage before we moved in there, and that was all it said.
Just answer her question.
What was the question again? I'm sorry. I'm just mad because I feel like I'm in here for no reason. I'm sorry. But
When's the last time? I'm sorry, sir, go ahead.
What was your question, ma'am? I'm sorry.
Before you came to jail, when was the last time you mowed a lawn for money?
Just a couple of days before then.
Okay. What kind of lawnmower do you have?
A self-pedal push mower.
How do you get to these places where you mow lawns?
I walk to them. I push my lawnmower with my weed on top of it, and I push them around the neighborhood. Everybody know me around the neighborhood, so I got some good yards up. But it took me all.
When's the last time? I'm sorry.
Go ahead.
When's the last time you smoked methamphetamine before you came to jail?
A long time. That's why I don't understand why would they say that. I haven't been in trouble in 4 or 5 years. I ain't been on meth in so long. I found my wife. When I got my wife, that's how long I haven't been on meth. I've been with her for 4 years.
But there was meth in your house, or in your
It wasn't no
garage.
meth. They said it was pills. There wasn't no meth in my house. It was some old pills that they found inside a pill bottle. It was Vicodin.
That's one of the
Wasn't no meth.
charges. That's one of the charges. So you're saying there wasn't any ice in your garage?
It shouldn't have been unless it was already in there. Ma'am, I live in a garage that somebody let me live in. They
Right.
still had stuff that belongs to other people was in that garage. Well, I didn't know about none of that. My wife lived there too. So if they found all that, why they didn't arrest her?
Well, but they did find a young man OD'd on the front lawn, right?
That's had to do with the front part of the house. I live in the garage. I live in the back. I do not know what's going on in the front. So
Were you aware that that young man told the police that he got it from you?
I was aware of that after the fact, but I have never ever sold drugs since I've been with my old lady. I go in mow yards, and that's what I do, trying to take care of my old lady the best I can. I never sold drugs to that kid. I got 4 kids myself. My youngest
Okay.
is 17. I would never hurt nobody's kids.
And let's talk about your criminal history. How many times have you been to TDC, Mr. Lyons?
One time, I've been to state
How many-
jail once.
You've been to state jail how many?
Once.
Okay, so you've been to state jail?
I've been to prison once, back in 2013 for possession. That's when I had a drug problem. I beat that drug problem 4 years ago.
And you've also been to state jail once?
Yeah, a long time ago, about the same time, ran at the same time, because I got put on. I went to prison, then I got out. I was on parole, and I caught another case while I was on parole, drug charge on patrol, and then I went back to doing 6 months, and I haven't been back in trouble since. That's when I met my old lady. I've been with my old lady ever since. I put that on everything I love. I mean, I can kiss the ground if I'm lying to you.
Well, your criminal history doesn't exactly say that they ran at the same time, does it?
Well, it was all around about the same time. I know I went to prison for possession. I got out with 6 months left. I don't know if I completed it or not, but I got back on drugs. Then I went to prison, state jail. Then I got out. Then I've been good ever since. I ain't been in no trouble ever since. And I damn sure ain't never sold no drugs to no kid.
So you went to prison. You went to prison once out of Kaufman County, right?
That's the one I went with the possession. That's the one. Then I got caught in Rockwall with Lester Graham. There was 4 people in the car, actually, and they all ganged up on me and put the charge on me, so I went ahead and took it. So I did 6 months state jail for that.
So you pled guilty to some. So you pled guilty to something you weren't guilty of.
Yes, ma'am. Basically, I did.
So you committed aggravated perjury.
So I guess I was just as guilty as they was. So let me rephrase that.
And in addition to that, you've been convicted of about 14, if I counted them correctly, misdemeanors,
Yes,
all
ma'am.
at different times.
Yeah, I've been misdemeanors. I have. But
All at different times. That's not counting ones that ran at the same time or anything like that.
I don't remember all of them, but I know I have been here quite a few for some misdemeanors. Yes, I have. I know me and my boss got into it one time. It was a terrorist threat, class B, and me and my girlfriend got into it a long time ago, in I think 2017, and just and that was it. I came back on the same one because I missed court with Joshua Winters, with Mr. Winter, whatever his name. I missed court.
So, about how many times have you missed court?
Just that one time, because I had got out the next day. I supposed to be reporting. I didn't find a ride in time, so. But I called him and let him know. I called the courtroom and let him know.
And the only time that you have ever successfully completed a probation was way back in 2004 that ended in 2006. Is that right?
That was the time I went to prison. Yeah, because I had a real bad drug problem then.
But you actually successfully finished that probation that you were put on in 2004.
Yes, ma'am.
Is that right?
Yes, ma'am. I think
And that's
so.
the only time you have ever, out of 14 misdemeanors and 2 felonies, that's the only time you have ever successfully completed a probation. Is that correct?
If that's what's on the paperwork, yes, ma'am.
Okay. So all those times, 14 separate misdemeanors that were all at different times and 2 felonies, so 16 total separate cases that you've been under court supervision for, and since 2004, you've never successfully abided by the conditions,
I always
correct?
did time. I got time served. I really did my time in jail and got time served for most of all of them. That was it. I
Well,
got
both of those felonies started out with a probation, correct?
one of them did, and the one in state jail, I went from state jail straight to I signed in Rockwall. The state jail, I went straight to state jail. I never was on
Okay.
probation for that. Only was on probation for that one. That's the one I completed. The rest of them was misdemeanors that I went ahead and just stayed and done the time on.
Fair
But
to
I
say there's been more than a dozen times that you've been put on supervision by a court that you failed it.
I really don't remember all that. I remember
I'll
don't. I you know, misdemeanors and I just go ahead and do my time. Or I was like, you know, I don't have the money or something. I go and rather go in jail and sit it out or go back to jail because I ain't got money to afford to pay, you know what I mean? But if I'm on something, I'm gonna try my best to complete it. Like I did the first time. If I got my mindset on it, I'm gonna complete it. If I mess up, I take that.
Because that's what you did back in 2004. You completed
ma'am.
it.
Yes, ma'am. I can complete anything. I promise.
I'll pass
Give
the
me a
witness,
chance,
Judge.
I would do it.
Mr. Lowe, your witness.
No more questions for the witness, Your Honor. Thank you.
All right, Mr. Lowe, any additional witnesses or evidence?
No, Your Honor.
State any additional witnesses or evidence?
No, Your Honor.
Mr. Lowe, would you like argument?
Yes, sir, Your Honor. And if the court will indulge me just for a few minutes to talk about these different offenses. So let me speak on a runaway, which is a class A misdemeanor. And it requires that a person commits an offense if he knowingly harbors a child, and he is criminally negligent about whether the child is younger than 18 years, and the relevant part is voluntarily absent from the child's home without the consent of the child's parent or guardian for a substantial length of time, or without their intent to return. So the facts are that Paula comes into Will's Point about 6:43.
Your Honor,
PM.
we're going to object to any recitation of facts by Mr. Lowe.
Are you arguing off of exhibits A and B, Mr. Lowe?
Your Honor. Yes, Your
Sir,
Honor.
you are, which one are you referring to?
This is Exhibit B, and I apologize. Exhibit B, Your Honor.
Okay,
So
the court's gonna overrules the objection.
according to Exhibit B, the call comes in at 6:43 PM. And the mother of the child says that the child has been missing since this morning, but it was a school day. And the child told her that she was being bullied at school. And the juvenile told the mama that she had legal documentation that said she had the right to do what she pleases. So the mother on that call at 6:43 tells law enforcement where she thinks her daughter is. Then at 12:54 AM, which is just the next morning, the law enforcement goes to 513 Van Zant Road 2140. And then shortly after that, they go to the address where there are 2 other people that live there, Mr. Covey and
His brother was living there at the time.
Hang on.
It's like
Hang on,
Okay.
Mr. Lowe, hang on. I can't, we're in argument here, so unless he has a law license and represent himself, I don't need to hear from him.
Right, yeah, you just let me, I was just collecting my thoughts.
I'm sorry.
So anyway, turns out when the police go to investigate the case that they determined that there was a person named Derek Silva that brought this girl over to the house, not to the garage, but to the house where Mr. Lyons lives. And the juvenile was not found in his part of the house, but in a bedroom of the house. And Mr. Silva jumps out of the window before the officers arrive. So the report indicates that Ms. Curry advised the police department just to arrest anybody that was there. So he was caught up in this. So first of all, with regard to that one, if the court does not grant a PR bond, we need a reasonable bond, which there is not evidence that there was from the child that she did not intend to return home, that she was gone for a substantial length of time, because they're only talking about 6 hours from the time the mother called the police, and that there's no evidence that Mr. Lyons harbored the child. And that's our argument on that one, Your Honor.
All right, any argument as to reasonable bail on the other 3 charges?
Yes, Your Honor. So according to the report that I filed as Exhibit A, I'm referring to, the way that case starts out is the mother of a juvenile who I think is about 17 years old. She finds him in her front yard, not his front yard, the mama's front yard. He's been gone for 48 hours away from home, and there's been no reports the child has been missing. But she finds him, calls the law enforcement. They come out and you get a statement from the juvenile that he was smoking, and I don't think the word is meth, it's just drugs, smoking drugs with Mr. Lyons and Mr. Covey. So the thing that's in the report about the juvenile, apparently this juvenile has been kicked out of Wills Point School for selling drugs. And I'm
nowhere in that report. That's a
All right.
total surmise by Mr. Lowe.
I apologize. It's been a long day, Your Honor. So anyway, so the law enforcement that gets a search warrant to search the premises where Mr. Lyons lives. And they go to do the search. Mr. Lyons is not there. He's somewhere else. They locate him somewhere else. But during the search, they find 0.91 grams of methamphetamine laying on a cell phone. Well, that's not where the juvenile said the drugs were. The juvenile said the drugs were in a drawer. So we're talking about 0.91 grams of methamphetamine where Mr. Lyons is not there. There's somebody else there, but he's not there. Also, with regard to the penalty group 2 offense, it's one Vicodin tablet. One Vicodin tablet in a I think it's in a pill bottle with somebody else's name. So I think that's a shorthand version of the facts, Your Honor. So I think that the bonds are totally ridiculous for one Vicodin tablet, 0.91 grams of methamphetamine, a case where a minor says after he's been missing 48 hours that he's been smoking methamphetamine with Mr. Lyons and another person. So we would urge the court to make reasonable bonds that would total not more than about $10,000 that Mr. Lyons says he can make. And that's our argument, Your Honor.
Thank you, Mr. Lowe. Ms. Curry.
Your Honor, I would simply point out that the speculation of Mr. Lowe that it was one pill is 100% not correct. That is not supported by that report. He's put a lot of evidence in front of this court today that is all based on what we don't even know whether that is a final report or not. The bonds in this case, Judge, are not unreasonable. $10,000 for a repeat offender on a state jail felony is not an unreasonable bond. $100,000 for supplying methamphetamine to a juvenile, even if he is 17, which again, there's no evidence of, is not an unreasonable bond. $50,000 for a Class A misdemeanor. If the court wants to adjust that bond to something more in line with what is traditionally done in this county, the state would have no objection to that, Your Honor. But $10,000 for state jail felonies, $100,000 for giving for a probable cause finding by a magistrate that this man was distributing methamphetamine, delivering methamphetamine to a minor is not an unreasonable bond, Judge.
Thank you, Mr. Curry. Mr. Lowe, last word.
So, Your Honor, the report indicates that there was one M366 hydrocodone and acetaminophen, I'm sorry, pill. So according to the report now, and so, Your Honor, the police, the district attorney's office is obviously able to get additional information if they wanted to complain about what's in these reports and the accuracy of it. And so, with that said, Your Honor, it's their business, however they want to do it. Bonds are just outrageous, need to be reduced.
All right, thank you, Mr. Lowe. All right, the court's going to take this, take arguments and evidence under advisement. The court's going to review exhibits A and B. We'll consider those in correlation with the arguments and testimony today, and the court will issue a ruling on the writ at the close of business today.
Thank you, Your Honor. That's all we have.
Thank you, Mr. Lowe. Thank you, Ms. Curry. I will, whatever decision I make, I'll make sure that Ms. Abraham sends a copy to both the state and to the defense.
Thank you, Your Honor.
All right, thank you, Mr. Lowe. Thank you, Ms. Curry.
You bet.
All right, I believe that does conclude the court's afternoon criminal docket, correct? Fabio, is there anyone else out there?
We're all clear.
All right, and we are adjourned for the day.
Yes, sir.